A very warm greetings to the KCGC TV viewers. I am Dr. Gunisha Saluja, Assistant Professor from Khalsa College of Law, Amritsar. Today here I will explain the concept of RTI, its constitutional status and the important features of RTI Act 2005. So first of all, what is RTI? RTI stands for Right to Information, and this right to information has given the status of fundamental right by the apex court of our country in its various pronouncements. We, the people of India, constituted ourselves to a democratic republic and give it to ourselves. That is, the nation and her people are governed by the Constitution of India. So, if we read preamble of Indian Constitution along with Article 19(1), then it made this clear that the liberty of thought is based on freedom of speech and expression. In 1995, Supreme Court in its judgment, State of UP versus Raj Narayan had made it clear that the genesis of right to information is liberty of thought and expression, which means that right to information is an invisible integral part of the freedom of speech and expression. In 1981, Justice Bhagwati in S.P. Gupta case, while emphasizing on the concept of democracy adopted by the Indian Constitution, observed that democratic government can survive only with the help of accountability. So the basic postulate of the accountability is that people should know about the functioning of the government. So it is only when people know about the functioning of government, then they can perform the role assigned to them by the democracy, and thus makes democracy an effective participatory democracy. Thereafter, in 1997, Justice Fazan Uddin of the Supreme Court in Rihajai Singh case has made this clear that in a democratic setup, there should be active and intelligent participation of the people in the affairs and the affairs of the community as well as of the state. It is very important that people should know about the cultural, social, political and economic life of the society as well as the burning topics and the important events of the day so that they can form broad opinion. Thereafter, in 2002, Justice M.B. Shah, in one of his landmark judgment, that is Union of India versus Association for Democratic Reforms, has moved one step ahead while holding right to information in democratic system as a concept recognized all throughout and is a natural right flowing from the concept of democracy. Thus, it is well established that right to information is an integral part of the freedom of speech and expression under Article 19(1) of the Indian Constitution. Democracy requires informed citizenry and transparency of information, which is very important for its functioning. The Right to Information Act 2005 has been enacted in this constitutional backdrop. The scheme of the Act contemplates for the setting out of the practical regime of right to information for the citizens to secure access to the information under the control of the public authority, to bring transparency and accountability in the functioning of every public authority. Thus, Right to Information Act 2005 inculcate a sense of openness in the democratic republic and intended to harmonize the conflict between the rights of the citizen to secure access to the information and the necessity to preserve confidentiality of the sensitive information. Now, so far as the features of Right to Information Act are concerned, first of all, under Section 2 of this Act, it is provided that any citizen can seek information from any department of the central or the state government or from any Panchayati Raj institution or from any organization or institution including NGOs established, constituted, owned, controlled or substantially financed directly or indirectly by the central government or the state government. This section further provides that every citizen has right to inspect any document of the public authority, inspect any work of the public authority, to ask any question from the public authority, or to make any inspection. The citizen can also take copy of the documents under the control of the public authority. They can also take samples of the material of the work of the public authority. Further, Section 5 of this Act provides that in each department of the public authority, one person must be appointed as PIO, that is Public Information Officer, by the public authority. The duty of this PIO, that is Public Information Officer, will be to accept the request forms from the citizen without asking for any reason, and thus provide them the information which they required. Further, this Section 5 provides that in each sub-district or divisional level, one person must be appointed as an Assistant Public Information Officer by the public authority, and his duty will be to accept the request from the citizens and then accept the appeal against the decision of the Public Information Officer and then send it to the appropriate authority. The next Section 6 provides that in case if any applicant want to make and file an application for seeking information, then he can file the application in written form or in electronic form, in English, Hindi, or in any language of the area, to Public Information Officer or to Assistant Public Information Officer with the prescribed fee, along with the prescribed fee. Then Section 6 further provides that in case if the applicant who want to seek information is asking for the information in oral form, then it is a duty of the Public Information Officer to render him assistance if he is unable to give the information in written form. This will be the duty of the Public Information Officer to provide him assistance to reduce it in written form. And further, this section provides that in case if Public Information Officer thinks that the information asked from him is not related to his department, then he can forward the application, or rather we can say he must forward the application to the required, relevant or related department within the 5 days, and he must inform the applicant about the same. Time limit in this case will be 35 days for providing the information for the purpose of information. Then further Section 7 provides that in case if any applicant is deaf, blind or otherwise impaired, then it will be the duty of the Public Information Officer to render him all assistance to seek that information, including the assistance to make any investigation also. The applicant has to make the payment of ₹10 while filing the application in case of the central government, and in case of the state governments the fees may vary from state to state. But in case if the applicant is below poverty line, or if the applicant is not getting the information within the prescribed time period, then he will get the information without making payment of any fees. Section 7 also further provides that in case if the applicant want the copy of any document under the control of the public authority, then he has to make the payment of fees of ₹2 in case of central government. In the case of state government, again it may vary from state to state. And in case if the applicant will not get the information within the prescribed time period, then he needs not to pay any fees to get the information. Then further, Section 8 provides the list of those very cases which are exempted from the disclosure. So in case if any applicant file an application to get the information which is enlisted in Section 8 under the heading of the exemption from disclosure, then Public Information Officer can refuse to give that information to the applicant. But suppose in case if the applicant is asking for the information is in public interest, then in that case, Public Information Officer will provide the information to the applicant even if it will be enlisted under Section 8. Then Section 11 provides that in case if information is related to third party information, then additional 10 days will be added in the prescribed time period, and it will be a duty of the Public Information Officer to inform the third party with whom the information is related. Public Information Officer has also to inform about the same to the applicant. Now, the applicant is also having the right to file an appeal. It is only in those cases where he is not getting the information within the prescribed time period, and or if he is not satisfied with the reasons recorded to him by the PIOs, then he is having the right to file an application within 30 days to the officer superior in rank to PIO appointed by the public authority as first appellate authority. And in case if he is not satisfied with the decision of the first appellate authority, then he is having the right to file second appeal within 90 days before the Central Information Commission or State Information Commission. And this right is given to the applicant under Section 19 of the Act. Then further Section 20 provides that in case if Public Information Officer is not providing the information to the applicant within the prescribed time period, or if he is intentionally causing some troubles to the applicant, or if he is charging high fees than the prescribed fees, or is intentionally giving some misleading, incorrect or incomplete information to the applicant, then applicant is having the right to complain against the PIO before Central Information Commission or State Information Commission. And in case if Public Information Officer who is not providing the requisite information to the applicant within the prescribed time period, or if he is failed to communicate the reason for the rejection of the order within the prescribed time period to the applicant, then this PIO will be liable to the penalty of rupees 250 per day for each day of the delay. The Information Commission may take disciplinary action against the Public Information Officer under the service rule applicable to him, and this provision is given in Section 20. Lastly, Section 22 of the Act provides that this Act is having overriding effect over other statutes. So we can say this Right to Information Act 2005 is providing a remedy to facilitate the exercise of right to information, and remedy itself is given in the preamble to this Act. The court has stated that this Right to Information Act 2005 needs a purposive interpretation looking into the purpose to this Act. And in case if any interpretation frustrates the purpose to this Act, then it must be mischieved. While coming to the conclusion, the Supreme Court has stated that preamble to the Act needs such interpretation, needs such construction, which will hopefully clean our democratic polity from the corrosive effect of the corruption and will infuse transparency in its functioning. Thank you very much.